What you are watching unfold right now is not just a political sideshow or a media spectacle, it is a direct stress test of the American system of law and order, and from where I sit, it has real consequences for U.S. credibility at home and abroad. When a former president publicly attacks a judge, a jury pool, and the integrity of the court itself, that is not merely rhetoric, it is an attempt to intimidate the very institution that stands between power and chaos. Adversaries around the world pay close attention to this kind of moment because they want to know whether the United States is governed by rules or by the loudest man in the room. If our courts can be bullied by political pressure, then every treaty we sign, every sanction we impose, and every warning we issue starts to look negotiable, and that is the definition of strategic weakness. What officially happened here is straightforward, even if the politics are not. A judge overseeing a criminal case against Donald Trump expanded a gag order after Trump repeatedly used public platforms to attack court staff, prosecutors, and their families. That is not a symbolic slap on the wrist. It is a formal legal action designed to prevent intimidation and protect the integrity of the proceedings. In any normal case, when a defendant keeps pushing after a judge has told him to stop, the next step is contempt of court, fines, or even detention. The fact that the defendant happens to be a former president does not change the statute, and it does not change the risk. If anything, it raises the stakes because every move is being watched not just by voters, but by hostile governments who are eager to see whether American institutions bend under pressure. Trump's behavior in this moment follows a pattern we have seen from authoritarian figures all over the world. When the law gets too close, they do not argue the facts. They attack the referee. They claim the courts are rigged. They claim prosecutors are political, and they try to mobilize public anger as a shield. That is not a legal strategy. It is a power strategy, and it is designed to make the cost of enforcing the law so high that institutions back down. From Moscow to Ankara to Caracas, this is how strong men operate, and the reason they do it is simple. If you can discredit the system, you never have to answer for what you did. The danger for the United States is not just whether Trump wins or loses a case, it is whether the judiciary demonstrates that it is immune to that kind of pressure. Judges do not exist to protect anyone's brand or political future, they exist to apply the law. When a gag order is expanded, that is the system asserting control over a defendant who is trying to run the courtroom from the outside. That is what a functioning democracy looks like, and it is what gives American power its legitimacy. If we start carving out exceptions for people who are famous, wealthy, or politically powerful, then we are telling the world that our rules are conditional, and once rules are conditional, they are no longer rules at all. That is why this confrontation matters far beyond one man or one trial, because the credibility of the United States has always rested on the idea that no individual is above the law. We lecture other countries about corruption, about independent courts, about due process, and we impose sanctions or diplomatic penalties when those standards are violated. If our own system flinches when a powerful figure decides to test it, every one of those arguments collapses. Beijing, Moscow, Tehran, and Pyongyang do not need propaganda when we hand them evidence that our institutions can be shaken by noise and intimidation. They will point to it and say, even America cannot enforce its own rules, so why should anyone listen to Washington? Trump is betting that political momentum can overwhelm legal reality, and that is a miscalculation with serious consequences. Courts are slow by design, but they are also stubborn. When a judge expands a gag order, it is because the behavior has crossed a threshold where the risk to the process is no longer theoretical. Attacking witnesses, court staff, or their families is not protected speech inside a criminal proceeding. It is potential obstruction. The law does not ask whether it is popular, it asks whether it is lawful. And when a defendant keeps ignoring that line, the judge is obligated to respond. That response is not vengeance, it is the enforcement of the very framework that keeps disputes from being settled by mob pressure. You have to understand how this looks from the outside. The United States claims to lead a global order based on rules, not raw force. We tell smaller countries that they are safer when disputes are handled in courts and institutions rather than through intimidation and violence. If a former president can try to bully a judge with public threats and political theater, And if that works, then our message to the world is exposed as hollow. Deterrence is not just about military power, it is about institutional power, the ability to say this is the law and it will be applied no matter who you are. The judge in this case is doing exactly what a judge is supposed to do, drawing a clear boundary and enforcing it. Expanding a gag order is a way of saying you can defend yourself in court, you can argue the facts, but you cannot poison the well or endanger people involved in the process. That is not political, it is procedural, and it is the same standard applied in thousands of cases every year across this country. The only difference here is the scale of the spotlight and the volume of the noise. What worries me is not that the system is responding, it is that so many people have been conditioned to see that response as an attack. When the law is treated as just another political weapon, the ground shifts under the entire republic. Adversaries thrive in that kind of confusion because it erodes unity and makes decisive action harder. If Americans cannot even agree that court orders should be followed, how are we supposed to project stability and resolve in a dangerous world where every weakness is exploited? This is where the broader pattern comes into focus, because what we are really watching is a collision between institutional authority and personal power, and history tells us how dangerous that can become when it is not resolved decisively. In countries that slide toward authoritarianism, it always starts with a leader claiming that the courts, the prosecutors, and the civil service are illegitimate obstacles to the will of the people. Once that idea takes root, the law becomes optional, and when the law becomes optional, force and fear take its place. The United States has avoided that fate for more than 2 centuries precisely because we built strong, boring, rules-based institutions that do not care who you voted for. Trump's approach is to turn every legal constraint into a political grievance, and that may rally supporters, but it does nothing to change the facts of a criminal case. Judges do not decide based on rallies or social media posts. They decide based on evidence and statutes. When a defendant keeps pushing after being warned, the system tightens the screws, not out of spite, but out of necessity. Contempt of court exists for one reason: to ensure that the courtroom is governed by law rather than by intimidation. That tool is now very much on the table, and the idea that a former president could face it is jarring, but it is also a testament to how seriously the judiciary takes its role. From a national security perspective, the lesson is simple and uncomfortable. The strength of the United States does not come only from aircraft carriers and nuclear deterrence. It comes from the predictability of our institutions. When allies sign agreements with us, they assume those agreements will be enforced by courts and upheld by administrations regardless of political drama. When adversaries calculate risk, they factor in whether American decisions will stick or be reversed by chaos. If our internal governance looks fragile, our external posture looks fragile too. We have spent decades urging fragile democracies to build independent judiciaries, to protect judges from political retaliation, and to let the law take its course even when it is inconvenient. Now we are being tested by our own standards. A judge telling a powerful defendant to stop interfering with a case is not tyranny. It is exactly what we have always said the rule of law requires. Backing away from that because the defendant is famous would be the real act of weakness. The human cost of this kind of confrontation is not abstract. Court staff, prosecutors, and their families are real people who face real threats when rhetoric turns reckless. Protecting them is not about politics, it is about basic responsibility. When a judge expands a gag order, it is to prevent harm and preserve a fair process, not to silence debate. The irony is that by refusing to respect that boundary, Trump only increases the likelihood of harsher consequences, and those consequences will not be a media narrative, they will be legal realities that cannot be spun away. And that brings us to the strategic risk of all of this, because when legal reality collides with political theater, something eventually gives, and it is rarely the law. Trump's gamble is that the system will blink, that judges and prosecutors will decide it is too messy, too controversial, too politically dangerous to enforce their own orders. That is exactly the kind of calculation that strong men everywhere try to force on institutions, and when it works, it becomes a green light for more abuse. If it fails here, it sends the opposite message, that even the most powerful figure in the country is still bound by the same rules as everyone else. For America's allies, this moment is a litmus test. Countries that rely on U.S. security guarantees and diplomatic commitments need to know that our government is not held hostage by any one personality. They need to know that if Washington signs a treaty, imposes a sanction, or makes a promise, it will be backed by a stable legal system that outlasts any single administration. When our courts show that they can operate independently, even under enormous pressure, that strengthens our alliances because it reinforces the idea that the United States is predictable and serious. For our adversaries, the stakes are just as high. Regimes that thrive on chaos and disinformation want to see American institutions paralyzed by internal conflict. They want to argue that democracy is a sham and that law is just a tool of the powerful. Every time a U.S. judge enforces a gag order against a politically explosive defendant, it undercuts that narrative. It shows that there are lines you cannot cross, no matter how loud or popular you are, and that is a form of soft power that no amount of propaganda can easily erase. The idea that a former president could be fined, sanctioned, or even briefly detained for contempt is uncomfortable. But discomfort is not a reason to abandon principle. The alternative, allowing open defiance of court orders, would be far worse. It would tell every future leader that the way to escape accountability is to build a big enough political shield and dare the system to act. That is how republics rot from the inside, not with a sudden coup, but with a slow erosion of enforcement. None of this means that Trump is guilty of the underlying charges. That is for a jury to decide. What it does mean is that the process has to be protected so that a jury can actually do its job. Gag orders, contempt powers, and judicial authority exist to keep that process intact. Undermining them for short-term political advantage would create long-term damage that no election result could fix. If we care about the United States remaining a country governed by law rather than by personality, this is the moment when that commitment is being measured. The responsibility here does not rest only on one defendant or one judge. It rests on all of us who claim to care about the stability and credibility of this country. When legal boundaries are tested, the reaction of the public and of political leaders matters almost as much as the ruling itself. If Americans start to see court orders as just another partisan move, then the social contract that holds a democracy together begins to fray. We can argue endlessly about policy, ideology, and elections, but when it comes to the courts, there has to be a shared understanding that their authority is real and binding. This is why I keep coming back to the international dimension, because the United States does not operate in a vacuum. Every crisis we face abroad, whether it is Russian aggression, Chinese coercion, or Iranian proxy warfare, depends on one central question. Do other actors believe that America means what it says? That belief is built on the idea that our institutions are stable and our commitments are enforced. If our own legal system looks like it can be shouted down, then our warnings and red lines overseas start to look negotiable as well. Trump's strategy of chaos might generate headlines and fundraising emails, but it does nothing to improve his legal position. Judges are not swayed by crowd size or online outrage. They are bound by rules that have been developed over centuries. When those rules are violated, the response is mechanical and often unforgiving. That is why contempt of court is such a powerful tool, because it strips away the theatrics and reduces everything to a simple question of compliance. Did you follow the order or did you not? In that binary world, politics offers very little shelter. There is also a moral dimension that should not be ignored. The people who work in and around the courts did not sign up to be targets of political intimidation. They are civil servants, lawyers, clerks, and families who deserve protection from threats and harassment. Enforcing a gag order is a way of saying that their safety and the integrity of the process matter more than anyone's desire to dominate the narrative. That is not censorship, it is the maintenance of a functioning justice system. If this line is not held, the consequences will ripple far beyond this case. Future defendants with money and influence will take note and push even harder. Public trust will erode further, and the idea of equal justice will become little more than a slogan. That is a risk no serious country can afford to take, especially one that claims to lead a world where rules are supposed to matter. The outcome here will help determine whether the United States continues to be seen as a nation of laws or slides toward something far more fragile. That is why this moment has to be understood not as a partisan drama, but as a test of national resolve, because a system that cannot enforce its own orders cannot enforce anything else. The judge in this case is not trying to make history, he is trying to do his job. And doing that job in the face of relentless pressure is exactly what gives the American legal system its power. If Trump ultimately faces fines or even brief detention for contempt, that will not be a political vendetta. It will be the predictable result of defying clear, lawful instructions. The message that sends at home and abroad is that the rules still apply, even when it is uncomfortable. We have reached a point where every action taken by the court will be interpreted through a political lens, but that does not change the underlying reality. The law either has authority or it does not. There is no middle ground where some people are bound and others are not. Once that line is crossed, every future dispute becomes a contest of who can apply the most pressure rather than who has the stronger legal case. That is not democracy. That is the road to permanent instability. What happens here will echo far beyond this courtroom. Every governor, every federal agency, every foreign government is watching to see whether the American system holds. If it does, it reinforces the idea that U.S. power rests on something deeper than personality or party. If it does not, then the world will conclude that America is entering a phase where institutions are optional and outcomes are negotiable. That perception would do more damage to U.S. influence than any single policy failure. This is why order matters, not the kind imposed by force, but the kind maintained by law. Courts exist so that disputes do not have to be settled in the streets, on social media, or through threats. When a defendant tries to move the battle outside the courtroom, the judge has no choice but to pull it back inside. That is not repression, it is the basic function of justice. The uncomfortable truth is that democracies only survive when they are willing to enforce rules against their own most powerful figures. That is what separates a republic from a personality cult. If we flinch now because the defendant is famous or polarizing, we teach every future leader that they can push just a little harder and get away with it. That is how accountability dies, not all at once, but in moments exactly like this. So when you hear claims that enforcing a gag order or threatening contempt is somehow authoritarian, remember where real authoritarianism begins. It begins when leaders are allowed to intimidate judges, endanger witnesses, and defy lawful orders without consequence. It begins when loyalty to a person replaces loyalty to the law. The court drawing a line here is not a threat to democracy, it is democracy defending itself. If you care about the strength of the United States, if you care about our ability to deter adversaries and lead allies, then you should care deeply about whether this line holds. Strong nations are built on strong institutions, and strong institutions are built on the simple principle that no one is above the rules. That is what is on trial right now, and that is why this case matters far more than any single political career.